Hello everyone, welcome back to Namalax Bengaluru presents current issue of the day episode number 199. Today we'll discuss one of the most controversial issue in current context of India, that is WAQF Amendment Act of 2025, and in that regard we'll discuss the age-old debate of Supreme Court versus government, that is the judiciary versus the executive. So the government brought certain amendments to WAQF Act, and now Supreme Court has stayed certain provisions from this WAQF Amendment Act. So in today's video, we'll discuss what is the background, why it is in news, and what is the WAQF Amendment Act of 2025, important provisions and Supreme Court observations, and also the legal implications of these observations. So without any delay, we'll start the discussion. First, it is relevant from GS paper 2, polity and governance, and the context is Supreme Court stayed crucial provisions of the WAQF Amendment Act of 2025, finding them prima facie arbitrary, but refused to strike down the entire law. So the first aspect, that finding them prima facie arbitrary, the opposition party considers this to be the victory of opposition party, and this part, refused to strike down the entire law, is considered as victory by the government. Okay, so this is the curious case of where both parties are trying to claim a victory out of judicial pronouncements. Next, first you should understand what is WAQF. WAQF is, according to Islamic law, it means the permanent dedication of property, movable or immovable, by a Muslim for religious, pious or charitable purpose recognized by Islam. Meaning the property becomes inalienable, that is, it cannot be gifted, sold or inherited. So basically it is a land which is given to a Muslim man, a Muslim person, for the use of charity, for pious, for religious purposes. So this is normally the WAQF. So before we understand the current provisions, we have to have an understanding of history of WAQF Act. So the WAQF was initially introduced to India with Muslim invaders, and this WAQF became a norm during the Delhi Sultanate and later solidified by Mughal rule. Since the Mughal and Delhi rule was run according to Sharia, there was no need for separate laws to deal with WAQF land. But starting from the 17th and 18th century, British overtook India. There was East India Company followed by British government. So there were clashes between the government, that is the British government in India, and religious institutions regarding the land. So they started bringing laws. So we'll discuss what are the laws before the independence and what are the laws after independence. So first, as I told you, WAQF acts were started with the advent of Delhi Sultanate and Mughal era, and in the British era, the first act was Musalman WAQF Hereditating Act of 1930. It was passed to reverse 1894 judgment. A 1894 judgment, the judiciary held that this WAQF land can be taken over by the government. That is what judiciary held. But Musalman WAQF Hereditating Act 1913 said that it reverts this judgment, meaning it recognized WAQF Alal Aulad, meaning family WAQF, as valid if the ultimate benefit went to charity, meaning the WAQF can be transferred from one person to another person in the family if it is used for charity. So this was the only law until British left India, and in the independent India, there were again the questions about property. And who should be in demand of, or who should be in control of this property. So in 1954, the first WAQF Act was brought by the independent India. It is first comprehensive law on WAQF in independent India. Under this, it set up state WAQF boards for better supervision, and aim was to prevent mismanagement and ensure WAQF property was used for its intended religious or charitable purposes. What happened with respect to this WAQF was initially for charitable or religious purposes, but over the period of time it was used for personal gains by the people holding or having rights over this work. In order to avoid this use of work for personal gains, government brought this act. Then a very significant 1995 act, that is WAQF Act of 1995, and the current amendments of 2025 are brought on this particular act. So what did this 1995 act do? It replaced 1954 act, as the old system was very weak. This act established Central Waqf Council, which is an advisory body under the Ministry of Minority Affairs. It strengthened state waqf boards with more powers such as manage and recover encroached waqf properties, and also allowed mandatory surveys of waqf properties was introduced in this act. And after this, in 2013 Amendment Act, there was another act, that is Waqf Amendment Act of 2013. In this, there were certain changes brought to plug in the loopholes and protect the properties under this article, under the 1995 Act. That is, it barred sale, gift, exchange or mortgage of waqf property. It gave powers to tribunals to resolve waqf disputes quickly. It prohibited alienation of waqf land for commercial purposes unless it directly benefits the waqf. And it required government agencies to consult waqf boards before acquiring waqf property. Okay, so you can see all these provisions are pro-waqf, all these provisions are pro-Muslims, all these provisions are against the government. Okay, so all these provisions are aimed at safeguarding the waqf property and reducing the powers of the government to take away this property. But then came 2025 Amendment Act. It brought drastic changes, whereas it changed the power from waqf boards or the waqf owners to government or government officials. So this is why this act was very controversial. Now we will see the new provisions of this 2025 Act. We will discuss them along with 1995 Act. So the provisions of 1995 and changes in 2025 Amendment Act. So under 1995, who can create the waqf? That is declaration, endowment or waqf by user. That is, a person can declare a waqf property and a person can endow it to another person for waqf, or a property can be declared as waqf by user. Meaning, if you are using a particular land for waqf property for a certain amount of period, then that land is automatically considered as waqf. In 2025 Amendment Act, this declaration and endowment was retained. However, this particular waqf by user was changed. That is, must have practiced Islam for at least 5 years. Waqf by user was abolished for future use. Okay, so this waqf by users was abolished for future use, and a person has to show that he is a Muslim in order to declare and in order to claim waqf by user on a particular waqf property. Next, the government or disputed property. Here in the 1995 Act, this disputed property was dealt by waqf boards or the tribunals, that is waqf tribunals handled these disputes. But in 2025 Act, these powers were given to collectors or the revenue officials, meaning executives. So from judiciary such as tribunals or the waqf boards, these were given to executives. Meaning collectors or revenue officials were empowered to inquire or government can alter waqf status. Then boards versus CWC composition. Mostly Muslims and women were included and sect representation was provided. In this new provisions, this Central Waqf Commission, it mandates that non-Muslim members should be included in this Central Waqf Commission, and new quotas for certain sects and backward classes, etc., was provided and also provided. Okay. So this particular act provided representation of non-Muslim members in Central Waqf Commission as well. Next, registration and surveillance. Registration was mandatory in 1995 Act as well, but it was poorly enforced. But in 2025 Act, stronger digital records and compulsory survey and registration. Okay. Next, the dispute resolution. Initially, it was done by waqf tribunals in 1995, and there were limited appeals to the High Court or to the Supreme Court. But in 2025 Act, more powers were shifted to executive officials such as collectors or revenue officials, and appellate rules were modified. So you can obviously see here, because of all these changes, you can see why 2025 Amendment Act was very controversial. Very controversial. The main rationale behind the government of India to bring this was, the rationale for this particular amendment was to improve governance and accountability of work properties, many of which were allegedly mismanaged or encroached upon or used for personal gains. Okay. Next, transparency. With better registers, digital records, it will provide more oversight. Then, preventing the misuse. For example, concerns raised that work by user was sometimes used to wrongly claim government land, or that property without formal documentation was being designated as work property. There was a famous case in Tamil Nadu where a whole village was considered as work property. This work property was established based on work by user, norm, and as a result, all these things, or all the people who were living that particular village, were made to leave the village, and as a result, it led to court cases, etc. So these kind of cases were on the rise, where many of the temple property was being claimed as work, or many of the villages were being claimed as work, and even the Ambani, okay, Ambani residence in Mumbai, Ambani residence in Mumbai was also considered or also claimed as part of work property because it was built on the work land, according to some sources. Okay, so many of the lands were being claimed as work, so government thought that we have to bring certain registrations, we have to bring certain regulations. So inclusivity. In the Central Work Committee, it ensures representation of various Muslim sects, backward classes, and non-Muslims, women in the structure, making this more inclusive. So these are the objectives and rationales. So why is it being criticized? What are the controversies here? First is about religious autonomy. That is, the very requirement of practicing Islam for 5 years may be considered discriminatory under Article 25 and 26. What is Article 25? Article 25 and Article 26 talks about freedom of religion. Freedom of religion. In Article 25, each individual has a right to practice, profess, and propagate a religion, and also promote a religion. However, it implicitly or explicitly says that no religious conversion, no right to religious conversation. And Article 26, it provides right to maintain property, a right to establish endowments, institutions for charitable purposes. So here, the very need of having 5 years or practicing Islam for 5 years is discriminatory under Article 25-26. And work by user abolition. That is, many historic and local works exist by usage without formal deeds. So abolition may threaten their status. Okay, because many of the work lands have been passed on generations and generations just by oral deeds or just by user deeds. Now, if you are going to remove this works by user, all these lands that have been transferred from one generation to another generation based on the use will be lost. So this is also controversial. Then executive overreach, that is, giving strong powers to district collectors in determining property status, potentially altering the work status without the judicial process, was seen as against the separation of power by the judiciary and Supreme Court as well. Next, risk to heritage. That is, many work properties are old, undocumented, or under customary usage. Removal of protections could lead to loss of heritage sites as well. So the very idea that work by user is abolished, and once the work by user is abolished, the land belongs to government. So government can use this land for its own purposes. So in case there is a monument, not document, undocumented monument is present on a work land that can be destroyed by the government, which is against the heritage, which poses threat or risk to heritage. Next, minority rights and constitutional validity. That is, allegations that amendments violate equality, right to property, and freedom of religion, and etc. So these are the controversies or criticism that are attached to 2025 Amendment Act of Work. Next, Supreme Court observations. So Supreme Court states key provisions on Work Amendment Act of 2025. So Supreme Court approach. A bench led by CJ B.R. Gawahi held that law is presumed unconstitutional but provisions affecting presumed constitutional, meaning it is at the moment considered constitutional. However, there are certain issues, there are certain questions that have to be addressed. That is, the provisions affecting the property rights, religious freedom require safeguards. So, certain aspects or certain provisions of this Amendment Act were stated, such as 5-year Islam practice clause. Supreme Court said, Act required a person creating work to prove their practice Islam for 5 years. Supreme Court asked, what is the clear mechanism? You have no mechanism to declare whether he has followed 5 years, whether he has followed Islam for 5 years or not. That is, Supreme Court found no clear mechanism to verify this, and provisions stayed until the government frames a process. Then Section 3, which talks about doubt over government property. That is, any work could lose its property or status if doubt was raised about it being government land. Okay, so court said that this is violation of separation of powers. That is, it is only the judiciary that can decide property title, whether it is a government or whether it belongs to WAQF. So it stated provisions allowing unilateral changes by revenue officers and state governments. And also the court put certain limits on the non-Muslim members. How many members has to be there in central WAQF commissions and in state WAQF boards. So these are the Supreme Court observations with regard to WAQF or WAQF Amendment Act. But the court also gave certain directions. That is, until WAQF Tribunal or High Court gives its final verdict, WAQF properties cannot be dispossessed or records altered. So here it is not the collectors or revenue officials or the government, of India or the government of a particular state. It is the tribunals or the judiciary or High Court that have to give final verdict on the WAQF properties. And mutawalis, that is managers, cannot create a third party rates on the disputed WAQF properties. Okay. Next, registration of WAQF is mandatory. Supreme Court said managers or mutawalis cannot avoid compliance when the law required registration since 1923. Court said, you are saying that we do not have registration documents, so we cannot provide WAQF by user titles or we cannot provide documents. But the court said registration was available from 1923 itself. What were you doing for almost a century? Why didn't you go for registration then? So Supreme Court said that from now WAQF registration is mandatory. If you do not register a WAQF, then if the government comes and High Court gives it in favor of government, then you lose the WAQF. Then constitutional and legal implications of this. That is, whether requiring someone to show 5 years of religious practice is reasonable or not, whether it is non-arbitrary or whether adequate safeguards exist to prevent the abuse or not. Then whether removing WAQF by user violates rights of communities which have long used property as WAQF without formal registration or deed, especially where documentation is lost. What is the case with respect to WAQF by user and in cases where the documentation is already lost? Whether vesting quasi-judicial or administrative powers with district collectors or revenue officials in deciding the property status violates separation of powers or not. Supreme Court said yes, it violates separation of powers. Supreme Court said yes, this is not reasonable, you have to provide a particular mechanism. Supreme Court said yes, this is in favor of government, that you were supposed to bring registration from 1923 itself. If you do not have registration, you have to get registered now, or else you are going to lose the land. However, the amendment balances state interest in protecting public property, preventing misuse versus religious or minority rights under the Constitution. So that right now the government under this act is balancing all the stakeholders, all the interests. We have to wait and see what the government is going to do with respect to directions given by the Supreme Court, whether it is going to bring changes or not. So after that, we have to wait for the issues to be decided by the Supreme Court. We'll have a detailed discussion on this then. For now, this is the current issue of the day. If you like the video, then please hit the like button, comment on it, and also share with your friends. And if you're new to the channel, please subscribe to the channel and click on the bell icon so that you don't miss any notification. With this, I will end the video. Jai Hind, Jai Karnataka.